Now, this is where it gets interesting for trust and estates attorneys, okay? I'm sure some of you have seen the type of will I talked about before, the credit shelter or bypass will, where everything doesn't go to the surviving spouse. We establish a trust for the surviving spouse on the first spouse's death. And as I mentioned, the reason why we do that is to take advantage of the first spouse's exemption so that it's not wasted. Well, if the surviving spouse can receive the entire exemption, that may eliminate the need to establish this type of trust, which is good for people who don't get around to doing any planning, not so great for lawyers who do the planning. Because now, I may very well do a simple will for a client, leaving everything to the spouse, because I don't have to worry about wasting that exemption. I'm going to have to file an estate tax return when that first spouse dies to take advantage of it. But even if I make a mistake and I don't do that sort, I don't do any sophisticated planning. Guy comes in, he tells me he's only worth $500,000. It turns out he's worth $500 million. That never happens, but certainly we do have clients that are worth a lot more than they tell me they are. Even if we had what we call a sweetheart will, leaving everything to each other, we would not lose the benefit of the first spouse's exemption because of desuet. So how much is the desuet? It's actually kind of complicated. It's the lesser of the basic exclusion amount or the basic exclusion amount of the surviving spouse's last deceased spouse over the combined amount of the deceased spouse's taxable estate plus adjusted taxable gifts. And my associate Chris, who's sitting here in the front row, when he was looking this over last night, said he thought I was missing some parentheses. But basically, let's go through it. The first term limits the desuet to the exclusion amount in effect at the time of the second spouse's death. So let's say that the first spouse dies in 2011, and 2013 comes around, and the 2010 Act expires, and they reenact it, and they say, we were too generous, and we're going to reduce the exemption from $5 million back down to $3.5 million. We thought that was a fair amount, and the alternative is to raise income tax rates or something else, and that's not really popular, or we'd have to cut something out of the budget, which we know how hard it is for Congress to do that. So they say we're going to reduce the exemption to $3.5 million, and then the wife dies. The surviving wife dies. She does not have the husband's full $5 million as the desuet. The desuet is $3.5 million because it was taken away with the change in the law. The second term means we are looking at the last deceased spouse's unused exemption. Okay? I've underlined and bolded last. Okay? And we'll get to that in a second. Well, let's talk about it now. What I mean by that is, if a spouse if husband dies, leaves everything to his wife, his $5 million desuet goes to his wife. Shortly thereafter, she remarries. And she marries a fairly wealthy individual who has already made gifts of $5 million during his lifetime. And then he dies. What is the value of the wife's desuet? Zero, okay? And I have some examples of how that works in a second.